I'm also very impressed by so many people as so early in the day. It may not be early for me, but it's certainly early for you. So I'm very, very happy to be here. As ICA president, I can say that we have a ICA Congress this year in Edinburgh. We've moved away from Miami, so different places. Now we are in Scotland. It is a beautiful program set up by a very good program committee. And we will also launch then a number of the product of the work product of a number of task forces like cybersecurity, like data protection. There's one on diversity as well. So there's a lot of activity going with an ICA that will be showcased there, and I hope a number of you can participate. That is also the time for me to say that the world does see that there's a lot of activity in Miami. There's a very lively arbitration market, and that is quite remarkable. Now to the topic of today, and I see time already passing. When I was asked to speak here, I was kind of looking for a topic that would be timely, and that right now I see emerging as one of the important ones in international arbitration. And so I thought maybe corruption before international arbitrators may be a topic. I don't know whether everyone sees the screen, but I do hope so. By now it is clear that corruption is an insidious plague that has a wide range of corrosive effects on societies, and that is a quote from the former Secretary General of the UN, Kofi Annan. He went on to say that it undermines democracy, the rule of law, leads to the violation of human rights, distorts markets, erodes the quality of life, and allows organized crime, terrorism, and other threats to human security to flourish. That awareness has changed in the last 20 years. It is obvious. I remember my early days, maybe it was more than 20 years ago, in international arbitration, where no one would ever speak openly about corruption. People had doubts. Maybe in this case there is something that is foul, but no one would raise it. Neither the parties nor the arbitrators. And I think that has changed. And I'd like to address this in the time I have today, and then we can go into questions. First, by the situations where corruption issues arise. And you will note that I've entitled this talk, Corruption Before the International Arbitrators. So I will not speak about situations where there is an allegation of corruption of the arbitrators. We have all been alerted by the fact of these arrestations of 14 arbitrators in Peru recently. These are cases that we might unfortunately see more. Whether founded or not is a completely different question. I very much vividly remember my very first arbitrations. It was 1990. This one was 1981. I was the last little associate in the team, and but I knew the chair because the chair of the tribunal had been my supervisor for my PhD thesis, which of course I had disclosed and no one had a problem with it. And at some point, someone from the client, not the main management person who was in the team, but someone less important, came to me and said, "Do you think the chairman would be sensitive to a gesture?" And I was very young, and I thought, did I understand what he was telling me? And I said, oh no, please, nothing. No, he will not be interested. It will really hurt your case a lot. I never heard about it anymore. But since then, I do know that this is not just a fantasy. It may well happen. But that is not the topic of my talk. The talk is about situations where the arbitrators have to deal with corruption defenses. Sometimes corruption can also be a basis for a claim. So these are the situations that I want to focus on now. It can be investment arbitration, it can be commercial arbitration. We tend to refer more to investment arbitration just because the awards are more visible. But then we do know that these issues also come up in commercial contract cases. I then would like to focus on the fact that there is a transnational consensus that corruption is illegal, so I will not spend much time on that. What is of more interest is that there are a number of problem areas where arbitrators may not always know what to do because there are no clear-cut rules, and that is what is more interesting to me, and then we'll get to a conclusion. So corruption is illegal, and there are many bases for many sources to substantiate that proposition. Obviously, there are international treaties. The main one is the UN Treaty Against Corruption of 2003. Then we have also an OECD treaty, that's an older one of 1997. We have the first treaty that was the Inter-American Treaty, 1996. Then we have practically all the national legislations do have rules against bribery. The Foreign Corrupt Practice Act is just one example with which you will be very familiar. It's not because these legislations are not always enforced that the rules do not exist. We also have a consensus that corruption is a breach of international or transnational public policy, and that is shows a global condemnation of bribery practices, so to say, a universal standard. The main case that has elaborated on this is World Duty Free versus Kenya. It was an investment case, but it was a contract case. And there is a long analysis that substantiates the existence of a transnational principle against corruption. Then we also have soft law texts. We have, for instance, the ICC has a number of texts that can be very helpful as an arbitrator because they elaborate, for instance, on red flags on which to which I will return. The OECD has a kind of a handbook. The UN has a declaration as well. So the consensus is very well established. To what extent are gifts, entertainment expenses, travel expenses, bribery or not? But that should not distract us from the overall consensus. So let's just say a few words about awards and court decisions that deal with corruption. We have in investment arbitration between 25 and 30 awards that deal with corruption issues, and at least 5 were outcome determinative. That was, and among those I've already referred to World Duty Free versus Kenya. That was a case where there was for those of you who are familiar with investment cases, this was a case where there was direct evidence because the CEO who had brought the money in a wallet to the president admitted having done so. So it's an incredible story. I always wait for the movie that would show this, but nobody has come up. Well, maybe.
It's the cost of doing business.
Netflix will do it.
Yes, maybe someone should tell them about the story. The other case that is often referred to in this context is metal tech versus Uzbekistan. I don't like talking about it that much because I chaired it, but that is a case where we used the red flag method because, contrary to World Duty Free, there was no direct evidence at all of corruption. There's of course also many commercial arbitration awards, and recently what has struck me is a number of court decisions in the context of commercial arbitrations. You are of course familiar with the Texas decisions in connection with the Petrobras bribery scheme. There's a number of decisions, there are probably more coming. In Europe we have seen Paris Court of Appeal decision in October, if I'm not mistaken, 2019, where the arbitrators had applied a high standard to accept corruption and had said that the high standard of proof was not met. And the court said, no, you cannot do this. You have a large number of indicators which show that there is corruption. And so they annulled the award. And they did reopen the proceedings on the evidence and applied their own standards using a lower standard of proof and reaching a conclusion that there was corruption. That, of course, is a warning for arbitrators. I take it as a warning. It tells arbitrators you have to be careful when you look at issues of corruption. Obviously, you may object, well, this is a review on the merits by the courts, and we all know that on annulment or enforcement proceedings, you don't do a review on the merits, you only look at the specific annulment grounds. But the answer to this is that this was the ground for, this was non-enforcement, but the would be the same thing for annulment, was breach of international public policy. And that is the only way a court on annulment or enforcement could look into the merits and review the merits of the decision. There is a similar, and that is why I think there was now a trend among courts to to review awards quite closely in corruption issues. There is another case called Barivin, the French case is an Alstom case from the Dutch courts, and that does exactly the same. It says the arbitrators have been too lax when it came to looking at corruption and dismissed the corruption allegations when they should have accepted them. Sometimes corruption is also used not as a shield against a claim, but as a sword to file a claim. There's one good example is EDF versus Romania. That is an investment case where the investor said, I have been discriminated against because I have refused to pay a bribe that was solicited by some government official. And that made me think, when I read about recent developments in this country, there is a bill on prevention of extortion of bribes that is pending in the House of Representatives. And that seeks to address the demand side, if I can say so, of corruption. So far, we're really dealing with the supply side. And we probably will diversify as we go along. Now, corruption can be raised at every stage. It can be jurisdiction. if you are in investment arbitration and there is a treaty that has a legality requirement to allow the investor to access arbitration. Otherwise, it would not be a jurisdictional issue. It will be an issue of merits. And that is the same in commercial arbitration. Of course, if the contract is null and void as a reason of on the ground of corruption, that does not mean that the arbitration clause would be null and void, and so the arbitrators do have jurisdiction to rule on corruption issues. Generally, it's more a merits issue. That is, one party raises this as a defense against the claim, and of course, the same issue can arise again on annulment or enforcement. The gray zones are, first of all, proof. I mean, it's notoriously difficult to prove corruption because it is concealed by nature. So the burden is on the party alleging corruption. I think there is agreement on this. There's a question there whether the burden can be shifted under certain circumstances. There's no agreement on this part, and I think was what I say later on red flags and the duty of investigate by arbitrators. This is an issue that may well go away. Then there is significant disagreement on the standard of proof. Some say, well, this is a very serious allegation to make. So if you make it, you have to have a very high level of evidence. Others say, no, because it's difficult to prove corruption, you should precisely not increase the requirements in terms of standard of proof. And so we have cases that go the two ways. It's either clear and convincing evidence or standards such as reasonable certainty, balance of probabilities, preponderance of the evidence. Essentially, it's either normal or high-end standard. And that debate, however, to me, will probably become academic with the trend that we now see of accepting red flags, because then you really focus on the indicators and on the actual facts. And if the facts are such that you consider there's sufficient red flags that there was corruption, then this will meet whatever the standard is. We have seen the red flags methodology applied in metal tech that I mentioned before. In Spentex, Uzbekistan, we've seen the Paris court saying this is what you should do. The flags, you probably all know the flags, really. It's no showing of legitimate services, a disproportion between the payments and the services. If you have consultants, quote unquote, who play the intermediaries, look at their qualifications. They may not have the right qualifications for the job they pretend doing. They may be close to people in power, which may also be an indicator. There are all kinds of different facts that, when you look at the case, make you worry maybe there's something wrong there. Now, another area of complexity is the tribunal's power or duty to investigate ex officio or sua sponte. There's no, it is obvious that an arbitrator has the power to order production of evidence that is embedded in the legal framework for the procedure, whatever it is. Now, more difficult is the question whether the tribunal has a duty to investigate and what triggers that duty if there is a duty. Now, that seems the message given by the Dutch courts and the French courts. That is not well settled at all in arbitral jurisprudence. I would submit that arbitrators render decisions which states accept as enforceable judgments, and this would entail, some argue, that the arbitrators owe duties not only to the parties in the dispute that agreed to their jurisdiction, but also to the international community as such. And one author, Catherine Rogers, whom you certainly know, wrote, "The modern international arbitrator is not simply an instrumentality of the parties' collective will expressed through the arbitration agreement, but instead an integral part of a larger system that depends in part on them performing their role as responsible custodians of the system." Now, one may have one view or the other, but as we see from recent court cases, maybe the part of custodians of the system will rather go in the direction of a duty to investigate. Now, if we were to say that there is a duty to investigate, the question is, when is it triggered? It is obvious that arbitrators do not have any enforcement or public powers to investigate, and they're not criminal prosecutors. That is, they're here to resolve a dispute. So I would say there must be sufficient factors of suspicion present for the arbitrator to start asking questions. And these suspicious circumstances should have a bearing on the claim in dispute, because if they have no impact on the claim, they may be contextual, but that is then not for the arbitrator to explore. Another difficult question is what are the consequences? If the arbitrator comes to the conclusion that indeed there are sufficient indications of corruption that meet the standard of proof, and therefore the claim will be denied, or if there is a legality requirement for jurisdiction will be denied. Now, World Duty Free said this by citing a very old English case from the 18th century that read, "No court will lend its aid to a man who founds his cause of action upon an immoral or illegal act." And that is the kind of thinking that generally justifies dismissal of claims or denial of jurisdiction. Somehow that leaves a sense of unfairness, right? Because it exonerates from responsibility the respondent who has necessarily participated in the wrongdoing. I try to express this in Metaltech by saying that findings on corruption often come down heavily on claimants, while possibly exonerating defendants that may have themselves been involved in the corrupt act. And the idea, however, is not to punish one party at the cost of the other, but rather to ensure the promotion of the rule of law, which entails that a court or tribunal cannot grant assistance to a party that has engaged in a corrupt act. That is the same thinking like the World Duty Free tribunal and the English court in the 18th century. Now, the Spentex versus Uzbekistan tribunal has not expressed it like that, but must have had a similar uneasy feeling about the outcome. And it did something that I thought was very creative. I'm not sure it was not beyond their mandate. They urged the respondent to donate $8 million to the UN program and fighting against corruption, and or else it would have to pay 100% of the costs of the arbitration and 75% of the costs of the claimant, which amounted to 17 million. And so obviously you make the calculation, and probably Uzbekistan has donated the money to the UN development program of the anti-corruption initiative. I don't know what happened afterwards. Others may know. That I'm not certain this is a good solution, because imposing this kind of conditions on a party may go beyond what an arbitrator is supposed to do in resolving the dispute. There are questions also whether there could be an unjust enrichment claim against the respondent, because the respondent has benefited either from the contract or from the investment, and yet not then being called into question into liability for its own wrongdoing. That is a very difficult proposition, because somehow it goes against the idea of international public policy. But it certainly needs to be further explored. A similar idea has also been flagged. Is estoppel. Would a respondent be stopped from raising corruption because of her involvement? That also would go against the idea that a court must raise it ex officio, because it's a matter of transnational or international public policy. So these are open questions. So far, no trend can be so far not practiced at all, but also I don't see a trend, at least in this direction. That leads me to my conclusion in the time's up as well. We certainly witness an evolution from eyes shut, which was the habit of the international arbitration community, to probably zero tolerance. I'm not blaming the international arbitration community, because it's just a reflection of what happens in society, and it's obvious that states now are fighting corruption much more intensely. The U.S. is maybe the best example for that. But also companies are very much aware of the compliance requirements that this implies, and that zero tolerance would be in favor of the promotion of the rule of law, which in the end is what we're trying to achieve here. Thank you. Happy to have